SH0CKED will deal with issues 1, 2, and 3.
May it please, Madam President, my ladies, may it please you, my Madam President, my ladies, my lords, my name is SH0CKED. I propose to deal with issue number 1, 2, and 3, and may I indicate that in dealing with those three issues, I'll be dealing with them together with Dr. Mudomi. My lords and my ladies, the three issues are to this effect. The first issue relates to the integrity of the technology, and the wording of that issue is whether the technology deployed by IEBC for the conduct of 2022 general elections met the standards of integrity, verifiability, security, transparency to guarantee accurate and verifiable results. The second issue relates to the question of whether there was interference with transmission, and it is to the effect whether there was interference with the uploading and transmission of Form 34A from the polling stations to the IEBC public portal. And the last issue that we will be dealing with Dr. Mudomi is the question of whether there are differences in Form 34A, and the wording is whether there was a difference between Form 34A uploaded to IEBC public portal and the Form 34A received at the National Tally Center and Form 34A issued to the agents at the polling stations. Now, my lords and my ladies, some of the issues that I will be discussing, or rather some of the issues we'll be discussing with my learned colleague, are issues that have been discussed, but we must mention them, especially considering what the petitioner in the petition that we are dealing with, the one by Honorable Raila, states at paragraph 35 of his petition. And in that petition, I'm just reading the second sentence of that plea, where he states, the evidence shows that the acts complained of were committed by third parties, senior employees of IEBC, acting in connivance with the second respondent in order to achieve a predetermined outcome in favor of the ninth respondent, and the ninth respondent for purposes of this petition is the first respondent. And so we are coming from the position that we maintain and insist that there was nothing that the first respondent did that could be said to have exceeded or to have amounted to collusion with the IEBC. And I would like to start my submissions by reference to the issue of Form 34A and what the first respondent and the second respondent did. My lords and my ladies, in MATIANG'I it was determined that Form 34A is for all practical purposes cast in stone. What Form 34A contains is the last word in respect to the wishes of the voters in the given polling station. And if it has to be in any way impeached, it is only when it has been brought to court. And so in recognition of that, the first respondent, as allowed in law, availed his agents at the polling stations to participate and watch over the process of the elections. And we wish to emphasize that The place of agents is a very material part of this petition. It is going to be a very important issue in a determination of this petition, because the bulk of the evidence in respect to the issue of Form 34A in this petition is the allegation by one Arnold Ochieng, an advocate, saying that he received Form 34As which showed that the data in the Form 34A in the public portal, the data in Form 34A that the agents of the petitioners had, and the data in Form 34A that were brought by the returning officers to the National Tally Center were different. And so the question of whether or not there were agents, whether they could be trusted, and so on and so forth is important. But for purposes of the first respondent, we wish to maintain the position that he had agents, and those agents have failed to him Form 34A through his lead agent. And after the Form 34As had been filled at the polling station, and all the agents available had been invited to endorse and confirm that the data captured in the Form 34A were true and accurate. After that had been done, the first copy of the Form 34A was then transmitted to the National Tally Center, the public portal. The other one was then taken to the National Tally Center. Now, I just want to emphasize two issues in that. One is that both the parties for the petitioner and the parties for the first respondent, had a chance to participate. The second thing I wish to emphasize, my lords and my ladies, is that in the entirety of the petition, none of the Form 34As at the point of the polling stations have been presented as having been challenged at any point. So that then the irresistible conclusion that should be made from the point at which the Form 34A originates is that those Form 34As represented an accurate state of affairs at the polling station, both in terms of data and in terms of the integrity of the process of voting and the counting of the votes. And as I said, then the Form 34As find their way to the National Tally Center, both in terms of transmission and the physical delivery by the returning officer. Again, agents for both parties were given a chance, and as allowed in law, the first respondent made sure that he had representation of his agents and has presented some of those agents to vindicate and verify that the data that was eventually verified at the National Tally Center were the accurate data of what happened at the polling station and passed on to the National Tally Center. I would like also to emphasize that the two things that were supposed to be done at the National Tally Center was to determine the data, and secondly, to establish the security features of the Form 34As. Having said that, my lords and my ladies, and considering that especially at issue number 3, your attention is on the propriety and the integrity of Form 34A, I must submit that the petitioners have not adduced any evidence of any challenge of any Form 34A at any point in the national tally. And this is the second chance they have, having had an initial chance at the polling stations. There is none of the Form 34As that have been challenged. It is with this state of affairs then, and as a result of this process, that eventually we have the declarations of the result coming out to indicate that the total valid votes cast were 14,213,027, being a product of a process that was interactive and where all the parties were involved. It is a product of this process also that comes out with the result that the first respondents' total votes were 7,176,141. Now, The process of verification of the Form 34As before they were transposed to Form 34C is a process that took 6 days. And over the period, all the 6 days, my lords and my ladies, as I already indicated, there was no objection to the verification of the Form 34As. It is our submission, my lords and my ladies, that the petitioner, through his agents, were happy with the process up to the last minute when the tallies were done, and it reflected a win for a party other than the one they wished. So that the reluctance and even this petition is based on objection as to who the Kenyans had wished to be their president. Having said that, then I would like to move on to the main party who has challenged the Form 34A. The witness the petitioner has brought for purposes of challenging Form 34A, being one Mr. Arnold Ochieng, and especially all the respondents have referred to him. Probably I shouldn't miss the opportunity to mention that Arnold Ochieng is an advocate. And some of the criticism we have about his affidavit and what it contains is to be looked at with the higher regard of the fact that being a lawyer, he should know more. One, my lords, he has sworn the affidavit and attached Form 34As when in his affidavit he acknowledges he was not an agent at any point. And so it brings in the point that that affidavit and what he says is hearsay. Number two, he produces about 20 Form 34As, and in all of them, he does not mention the agent who gave him. He does not say, I received. He says this Form 34A is defective because it has data that is at variance with the public portal. It is at variance with Form 34A that was brought to the National Tally Center. But he does not say at any point which of the agents gave him that Form 34A. Number three, he brings the Form 34As and says they were given to him in terms of either photocopies or photographs from the agents who were on the ground because he was not there. But he does not produce a certificate of electronic evidence to show that those agents have confirmed that indeed this Form 34A was properly generated and is capable of being treated as evidence of any property value in the consideration of your case, of this case, sorry. And lastly, my lords and my ladies, Mr. Ochieng then certifies that these Form 34As that I'm producing, having skipped, of course, certification from the point of agents, he does a certificate himself saying this Form 34As that he's presenting to court meets the criteria required by Section 106 of the Evidence Act, the electronic evidence. That certificate, my lords and my ladies, says it is a certification of a production of a video, when in fact the attachment he produces are forms, Form 34A. And so, my lords and my ladies, in considering that item number 3, the issue number 3, we pray that you take into account that the principal witness on that issue of Form 34A has adduced absolutely nothing in support of the petitioner's case. In firstly, my lords and my ladies, on our part as the first and second respondents, and similar to what the third and the fourth respondent did, was to pick the Form 34As that the petitioner had brought and said they demonstrate that the Form 34As lacked integrity. And then we went to those polling stations and asked the agents and the presiding officers in those polling stations to confirm to us what they know about the Form 34As that Arnold had brought to this court. And my lords and my ladies will see that we have attached over 6 affidavits from the agents, and each of them say each of those forms were falsified. And I'm using the words falsified to be polite about the issue. I know my colleagues have said worse than that on that issue. The third issue I wish to take up on the issue of Form 34A, the first one was the process. The second one is the evidence against the first and second respondent on that. The third issue I wish to take up about that Form 34A relates to the issue of how they were housed in the public portal and the transmission. And the first point I wish to observe and submit, my lords and my ladies, is that we pray that the court keeps the conscious awareness that the elections were not electronic elections. They were manual. The only issue that was electronic was voter registration, voter verification, voter identification, and the results transmission. And in these proceedings, our focus and attention relates to transmission. Having said that then, my lords and my ladies, we pray that the court takes in on board the point that is made in Section 39 of the Elections Act, Section 39 1F, and the decision of this court in Odinga 2013, paragraph 237. At Section 39, it is indicated that the propriety of the election process will not be defeated by reason of results transmission. And in the Odinga 2013, the court said that it takes judicial notice that it is possible that technology can fail and our elections will not be held captive to the likelihood and the risks that relate to technology. Now, my lords, we would like them to submit to this effect, that assuming for argument's sake, it is true that there were any deficiencies or any defects in the process of the transmission of the results, it is our submission that that did not impeach the elections, because eventually the election and the results were declared based on the hard copies that were brought by the returning officers from the constituencies. They were not based on the portal, that the portal is meant for comfort, for transparency, for accountability. It is not meant to represent the accurate and the true results. It is the hard copy that is taken to the National Tally Center for purposes of verification in terms of data and for security features. Two last issues on that issue, my lords and my ladies. The first one, my lords and my ladies, is we pray that in reflecting on this issue of Form 34A and the alleged discrepancies and improprieties, you do note that the petitioners do not point out the variances that they are alleging exist. But most importantly, they do not come up with their own tally. They are saying the results that I just read a few minutes ago, that is 14,213,027 being the total valid votes cast, and the 7,176,141 in favor of the first respondent are inaccurate. They say that. However, they do not come forward and say this is the correct tally and it is based on what. And we pray that you take that on board in considering that issue. With that, my lords and my ladies, I submit that the petitioners have failed to discharge their burden of proof, which is above balance of probabilities, to demonstrate that indeed there was any deficiency or defect in Form 34A or in their transmission, and I adopt the submissions made by my colleagues, especially for IEBC. The second issue I wish to address, my lords and my ladies, is related to the same issue of transmission, being the alleged logs that third parties are said to have used to interfere and in the words of the petitioner, to stage, to dump the Form 34S. And my lords and my ladies will notice that in support of this contention, the petitioners are relying primarily on two affidavits, one by John Kidongo and the other one by Benson Wesonga. And the chain of events is to this effect. John Kidongo swears an affidavit that he sat in some discreet place. He says somewhere in Karen. I don't know what he has against Karen. He says he sat somewhere in Karen with someone whose identity he doesn't disclose, and he was told that some log particulars were used to interfere with the results. Then we have the Nwesonga step in and purport to analyze those logs and say, indeed, his observation as an expert in IT is that those logs were used to interfere with the results. And we would like to observe a couple of things. The first one, my lords, as already submitted by my colleagues in the IBC, for the IBC, is that that evidence from Kidongo is a third level hearsay. It is based on information given to somebody who is not disclosed, and Kidongo is the third person in that order. By the time Benson Wesonga is purporting to do analysis, he is at fourth level of hearsay. But more interestingly, my lords, we took time to look at the logs, and what struck us was that one of the logs which had been manipulated, one of the logs escaped their attention, and it has a date 2017. I know my learned friend Mahat already explained how in the 2017 polling stations were used as part of those, possibly the matrix of the logs. On our part, we noticed the date 2017, and it piqued our interest. When we checked, my lord, we realized that indeed the particulars of those logs, or substantial parts of those logs, were parts of logs that had been posted by his friend, Professor Makau Mutua, in 2017. And they had just been lifted and purported to be the logs that had been used in 2022. In response, and without being technical, we put in an affidavit saying, these logs were the one tweeted in 2017, these logs were the one used in the petition in 2017. And what then Mark Kidongo did was to make a fast retreat and saw an affidavit saying, I am retracting what I said, I am retracting the allegations that those were the logs that were used. Now, unlike the first affidavit where he had said he had been given those logs by somebody else, he now comes and disowns those logs personally. He does not say, I have gone back to the shadowy person that I had used, and he has told me that I am mistaken. He now takes responsibility for it and says they are wrong. But he not only says that and just leaves it there. He says, by the way, please understand me, they were meant for demo. He says that I had indicated them and they were meant for demo. And you look at that, you'll see that in his affidavit of the 28th August 2022. Now, my lords, more importantly for our petition, more importantly for our response to the petition, is that those are the only logs that had been presented for purposes, in terms of logs, those were the only logs that had been presented for purposes of challenging this petition, these elections. With Kidongo's withdrawal of those logs, my lords and my ladies, we would have expected that then that element of the petition would not be given to you. You would not need to consider them again because they have been withdrawn. What happens then? One Justice Nyangaya walks in as a respondent and introduces new set of logs. longer, he jumps into those ones and now analyzes them and again says they demonstrate and indicate that there was interference with the transmission and the public portal. My lords, as my senior counsel Ngati had indicated, we have a scenario where the petitioners were able to have friends in the part of the case of the respondents. And then we have the situation where Nyangaya as a respondent now makes a new petition, my lords. And we would like that to be an issue for your consideration. Whether you will look at the new logs that have been introduced by Nyangaya in the cause and purport that he is a respondent when in fact he is an extension and a surrogate extension of the petition. We submit, my lords, that and my ladies, that you should reject the attempt to have introduced a new petition, one, and number two, a petition that was filed out of time, and number three, that has been innovatively done by the petitioners to extend their case. We pray that you do find that the issues of the logs are dead and they are not available for your consideration. As my learned friend Mr. Mhat said, and Abdikadir said, we would pray, and Mr. Gumbo also said, we would pray that you apply your minds to the scenario where parties come and present to you petitions purporting them to be well-founded when in fact they are based on falsehoods, my lords. And my lords, we challenge you to exercise your capacity to be annoyed at this kind of a conduct. Lastly, my lords and my ladies, I have been instructed to also say something about the arguments made by my friend Omutata in petition number 7, in which he argues that the data shows that indeed none of the contestants achieved more than 50+1. And I just want to say three things, my lords and my ladies. Number one is that Omutata, in paragraph 14 of his petition says the 65.4% that he's using was picked on the 9th of August to 2022. My lords, as Ma had already explained, that figure kept changing, as by close of day on the 9th of August it had changed to 64.6, and by close of all the data it was 64.7. My lords, he used a percentage that was not static but was moving. The second thing, my lords, is that he used the wrong denominator. He calculated his data using the total registered voters as opposed to total registered voters in respect to the KIMs that had reported their data. And I think Mr. Ma had already explained that very well. And for all those reasons, my lord, we pray that you do not come to any temptation that indeed the 9th respondent did not achieve 50+1, but indeed to adopt the calculations as done by IBC. Thank you very much, my lords. I pray and request to cede ground to my friend, Dr. Thiongolo.
My lady and my lords, my name is V0MITNG.